All right, hi, welcome back. Attorney Steve Vondran, Sunday edition. Lots of stuff going on. Can I get a woohoo?
Woohoo!
All right, about time somebody appreciates my videos. I'm just joking. So, anyway, hey, I wanted to talk real quick about self defense and what we're seeing right now with this Rayshard Brooks case, the George Floyd case. It seems like the media is really coming out with a lot of different cases right now dealing with this. So I wanted to talk about the Rayshard Brooks case. This was the case from Atlanta where this was outside the Wendy's, where the guy was basically got into, apparently was sleeping in his car, as I understand it. And you always got to wait for the facts to come out because there's always more that meets the eye originally. So a lot of people like to jump to conclusions. I like to wait until the facts come out, but I'm going to tell you what we know so far. And sometimes it takes a while actually to get the facts out. But this is general legal information only and not legal advice. But so Rayshard Brooks was, from what I understand, was in his car napping or sleeping or something outside of Wendy's. There was a bunch of people in the drive-thru, and an officer spotted him, and either somebody called or who knows what happened. But next thing you know, they're giving him a DUI field sobriety test. That's where you have the three or four different tests that they'll give you. And they also wanted a breathalyzer test. Well, he gave the breathalyzer, and I saw it looked like they had him walking the line and, the balance tests and all that stuff. So, which is, like a lot of people say, it's not even easy when you're sober sometimes, so. But anyway, so they did that, and then it turned into a scuffle. They tried to place Mr. Brooks under arrest. He did not want to be placed under arrest. He resisted the arrest. The scuffle ensued. He grabbed the cop's taser gun and started running. And as he was running, you can see him turning back. Looks like what he was doing was trying to shoot at one of the officers that was chasing him. Okay, so that's the Rayshard Brooks case. Next thing you know, there's protests and riots in Atlanta, burning down the Wendy's. All kinds of stuff going on. So that's the one case we're going to talk about. George Floyd is the other. I think everybody saw that gruesome video with the cop putting his knee on that guy's neck for, 6, 7, 8 minutes, whatever it was. And it couldn't have been more blatant. So I want to kind of compare and contrast those two cases with two United States Supreme Court cases, which could be controlling or which could play a role in whether or not these officers are found guilty. And whether or not there's justice and whether or not there's acquittals or whether or not there's even charges. So the two cases I have here are Tennessee versus Garner from a 1985 case from the Supreme Court, and then the more recent Graham versus Connor, which is 1989. So let's start on the bottom. Let's take a look. Now, in this case, it says a law enforcement officer. They were pursuing some guy, and I think in this case it dealt with a burglary, like a nonviolent burglary, and they were chasing this guy and apparently shot him. And case went to trial, and there was some question over whether this statute was constitutional and whatnot. As you can see, Fourth Amendment protects against unreasonable searches and seizures. Okay, a search, obviously, searching somebody's pockets, their house, their briefcase, their glove box, and a seizure is anything from a stop and frisk to a handcuffing. Okay, this case says, as you can see in red, when a law enforcement officer is pursuing a fleeing suspect. Now, that's not George Floyd. George Floyd was kind of handcuffed, and so this case may not really apply to his set of facts. It says when a law enforcement officer is pursuing a fleeing suspect, and that's what we had here with the Brooks case. Well, he was a fleeing suspect. The officer may not use deadly force, which is what happened here, deadly force. I think it was 3 shots from what I heard, unless the officer has probable cause. And from my understanding of criminal law back in my law school days, probable cause is a fairly low standard in my estimation, because many cases find probable cause. Unless the officer has probable cause to believe the suspect poses a significant threat of death or serious physical injury to the officers or others. Now, this is where I think the Brooks case requires a little bit of analysis. So he was running, there was a Wendy's line there, and he had a taser. We do know, you can search the internet, tasers have caused death before. People can get shot with the taser and then go into like a cardiac arrest. So it could be deemed a dangerous weapon. He's fleeing. Is he a threat to everybody in the line at Wendy's? Well, probably not. It didn't look like there was any threat to the people in the line, but he was running by. There were like kids in the car. But when he turned back, and like I said, we got to wait till all the facts come out. Everybody is innocent until proved guilty or pleading guilty in a court of law. So we don't jump to those conclusions. But it looked like he was turning back and pointing the taser. It looked like it went off. It looked like he took a shot at the officer. And then there was 3 shots. That's about what I could tell of it, okay? So, but if the officer can show probable cause, like I said, I believe that to be a lower standard. Some of my criminal law associates can chime in on that. If they believe that the suspect posed a significant threat of death or serious physical injury, so it's not even death, it's serious physical injury. I mean, in a taser, I don't know, does a taser do that on normal circumstances? That's stuff things lawyers can argue in court, okay? To the injury to the officer or others. So you can see there's some wiggle room in there in the Tennessee versus Garner case. Again, I don't think there was any wiggle room in the George Floyd case, but I think this is something that's going to be looked at, a case that's probably going to be cited in the Brooks case. Now, let's go to the more recent case of Graham versus Connor, 1989. So this was decided 4 years later. And for those of you who don't know, the United States Supreme Court is, when they make a decision, it's known as the Supreme law of the land, okay? Oftentimes the Supreme Court is known as the court of last resort, okay? So this is the United States Supreme Court speaking here. You had a case, the court determined that an objective reasonableness standard should apply to a civilian's claim that law enforcement officials used excessive force in the course of making an arrest, an investigatory stop, or other seizure of his person. Those are the Fourth Amendment we're talking about, okay? Fourth Amendment protects you from unreasonable searches and seizures. It's applicable to all people via the states, via the 14th Amendment to the United States Constitution, okay? But here's the nuggets. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, a reasonable offer on the scene, rather than with the benefit of 20/20 hindsight vision, okay? So this is what we call an objective standard. This is, if you were the officer, you were there, you were faced with the same situation, it was the same time at night, it was the same setting, it was the same set of facts, it was the same crime. Would a reasonable officer have done what you did, that officer, okay? I think we look at the George Floyd case, I think everybody pretty much says, wow, that's like a slam dunk. I mean, that's not reasonable. I mean, I don't see any way, he may try something, but I don't see any way to actually make the argument that that was reasonable. I do see the officers in the Brooks case, however, trying to make that argument using this case to say, well, you know, what would you have done with you if you were there in the heat of the moment? This guy shooting at you and running, and it also looked like that he'd also thrown a punch, from what I could tell from the video. But again, we'll reserve all the facts and we'll see what happens. But so you have a guy that was apparently, according to the officer, was drunk. Mr. Brooks said he had a drink and a half of margarita, I think is what he said. So they did breathalyze him, so we'll wait and see what those numbers come out to be. That may provide some additional facts. But he, like I said, it looked like he resisted arrest. You probably have like a drunk in public, possibly, depending on how that goes. And then you have, it looked like resisting arrest and potentially, from what I saw, an assault on one of the officers, which is probably a felony. You'd probably have to check the state law in Georgia to see what it says, but it's probably a felony on a police officer, I would imagine. but I'm not licensed here, so I can't really opine on that. But that is the perspective, the reasonable officer on the scene. It's not, hey, watching it on TV later, yeah, you shouldn't have done that. It's the heat of the moment is what I would call this. The court then outlined a non-exhaustive list of factors for determining when the officer's use of force is objectively reasonable. Okay, so here's what they got to show. They're going to look at the severity of the crime at issue. Okay, if it's a rape or a forced robbery or something, that may be murder. That may be something more serious, obviously. This was a DUI. This was a resisting arrest. So that's one of the factors that will probably be looked at in the Brooks case. Whether the suspect poses an immediate threat. This is what I think is going to be the big one here. Whether the suspect poses an immediate threat to the safety of the officer or others, okay? Now, I think they're probably going to argue that, yes, he did. He turned around, he was running, he pointed. Everything happened so fast. Everything can change in a New York minute, as the song goes, okay? And finally, another factor, whether he is actively resisting arrest, looks to be the case, or attempting to evade arrest by flight. So it looks like that one could be dead on, in other words, okay? And not intending that pun, by the way. But so those are two cases, United States Supreme Court cases. I think you could see these. Things are just getting crazy right now. I would ask everybody just to keep their heads. Cooler heads should prevail. Let's let the justice system do its work. People will say, no justice, no peace. But let's let the system do its job. And if it doesn't work at the end of the day, yes, that's a problem too. Okay, but that's two cases, and I think a good way to kind of analyze the facts of these cases and any other cases of excessive force. And don't forget, these are just the criminal case. These cases of the prosecution will be criminal cases, but there'll also be a civil case, which is going to have a lower standard of proof. Once the deceased family, usually they will file a civil suit, and the standard is not beyond a reasonable doubt. It's not this; it's lower preponderance of the evidence. Okay, so usually you have the criminal case that deals with potential convictions of the officers. And then the civil case, which is a money case. That's for money, compensation, compensatory damages, okay? So I hope that helps you understand it. I normally don't do videos on Sunday, but everybody's talking about this. I wanted just to chip in my 2 cents. Again, not legal advice. Again, everybody is innocent until proven guilty. And please, please tell all your friends that. Why? Because one day it could be you sitting there. You could be sitting there. You want that presumption of innocent, as we all should, and that's the basis of a civil society. So please be nice to each other. Be kind. I hope this helps. There's 2 great cases for you, Graham versus Connor and Tennessee versus Garner. Okay? Have a great day.